Government of Bihar and our chief guest for today. Senior Advocate Prashant Kumar Shahi is the Advocate General of Bihar. Mr. Shahi has been appointed to this constitutional post for the second time after 2005. He's also been the Advocate General of Bihar in the past from 2005 to 2010. Opening of legal aid services authorities, restructuring of police and administrative reforms of state government were mainly augmented by incisive legal opinion dispatched from his office to the state government. From 2010 to 2015, Mr. Shahi was a cabinet minister and held education and forest and environment department portfolios in the state government. He returned to practice in the Patna High Court in 2015. May I now invite Shri Prashant Kumar Shahi Ji, Advocate General, Government of Bihar, and our Honorable Chief Guest for the day to deliver his address on the role of judiciary in tackling gender-based violence. Welcome, sir.
Mr. Sunil Kumar, Honorable Minister for Education, Mr. Nishit Prakash, Harjotji, Ms. Girja Borkar, Ms. Sophia, all distinguished senior officials from Indian Administrative Service, Indian Police Service, panelists, distinguished participants, and friends from media. Very good morning to everybody. I congratulate Mr. Nishit for keeping him connected to his roots. He briefly discussed about his association in the past, but he keeps working for the state of Bihar. He worked in the past, he's working now, and in a multi-dimensional manner. I have known him since his early days because of his father, Mr. Rajyavardhan Sharma. In 2012 perhaps, if I am not wrong, he was working on project of education department. We had together participated in the workshop which was organized in London School of Economics. Impact of incentives such as cycle amongst marginalized section of the state, especially girls, and the research which he undertook under the aegis of World Bank was replicated in many of the African countries. It indeed was an intervention by the state government which changed the entire paradigm of girl education in the state of Bihar. There are several interventions. I will be coming to the subject which has been assigned to me, role of judiciary, later. But before that, I will be failing if I do not point out the interventions made by the state of Bihar in the past about 20 years. It started in 2006. I was associated in drafting the legislation, Panchayat Raj Act. And Honorable Chief Minister, under his leadership, we took a very revolutionary step of empowering the woman by providing 50% of the offices in local self-government in favor of the woman. That was really the first step in the state of Bihar, which changed not only the politics, but the entire complexion of governance prospect of immediately containing left-wing extremism, women empowerment, so much so that later on, practically, women participation in local self-governance increased from 50% and it is roughly about 57-58%. Unless you empower a marginalized section of the society, which the women were being treated, it would be difficult to expect that they would be in a position to defend any kind of discrimination, including violence. So it started, the government's intervention started with that. From 2006, when the elections were held, and in the first 10 years, there was a general belief that even though the women representatives in local self-government were there, but they were only for the namesake, and their husband or their progeny would really be managing the affairs for and on behalf of women. However, contrary to this perception, things proved otherwise. The husbands became in course of time, husbands became the manager of the women representative who were the office bearers. In this way, things started changing. Then intervention was introduced through various schemes in the education department. One of the most successful experiment was providing two things, cycle and dress. Because of Mike, because of poverty and deprivation, girls were ashamed of attending schools because they did not have proper clothing. So dress and cycle. This transformed women education. This was second step of empowerment. Third major step was providing 35% reservation in every service of the state. Today one can go, move anywhere, you will find women police matching with the number of male police personnel. Yes, initial hiccups would be there, some inhibitions would be there, but definitely in course of time, they will empower themselves. In continuation of that, the initiative of self-help group, if most of us being associated with administration, have been traveling across the state, one can go and visit any rural area. You will find that even in marketplace, women would be outnumbering male. If you visit any market, any rural market after 12 o'clock, 12 noon, you will go and see and find out. This initially Ajivika converted into Jivika. This self-help group has created awareness, empowered economically and socially. This has transformed not only women, but the entire state the rural economy has completely transformed because of contribution by the self-help group. This kind of initiative has done wonders. Of course, I do not claim that all maladies have been taken care of. Nonetheless, these are some of the steps which has created a very remarkable impact in improving things which used to exist prior to these interventions. Violence, when we discuss about violence, and especially gender-centric violence, then we should bear in mind that it is distinguishable from other type of violence, both from the perspective of perpetrators and of the victim. Gender-based violence cannot be seen just as a regular law and order problem, rooted as it is in structural inequalities, stereotypical notions, historical and socio-cultural context. It includes acts that result in physical, sexual or psychological weaknesses. However, in recent past, there has been welcome departure from tendency to sweep this problem under the carpet. Sexual violence, for example, girls or women, they have a kind of inhibition in reporting or even discussing because of the social stigma and taboo which they would be facing. But this thinking has been changing, and now if there is an incident, the tendency to report and ensure that perpetrators are punished and some reformative steps are taken is gradually changing, gradually increasing. Criminal justice system, so far is concerned, it has two stakeholders: the law enforcement agencies and judiciary. They are the two main players which have the responsibility of tackling the problem, reforming it, punishing, reparation, reform. So these two stakeholders have major role to play. There are number of legislations in the past which have been introduced, namely Protection of Women from Domestic Violence Act 2005, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, which we commonly understand as POSH. Dowry Prohibition Act is an old act. Protection of Children from Sexual Offences Act 2012. Indecent Representation of Women Prohibition Act 1986, apart from gender-based offences in earlier IPC, now Bharatiya Nyaya Sanhita, and provisions contained in Bharatiya Nyaya Suraksha Sanhita, BNSS. Law, so to say, has adequate provisions. It is not only law which will eradicate this problem, but its implementation. coupled with awareness in the society and empowerment of women. These three combined will have to be strengthened, will have to be given an impetus so that they work in tandem, and then alone we can conceive of a situation where gender violence can be contained. Judiciary, especially Supreme Court of India, is alive. High courts are alive to the situation. I recollect 3 cases of rape or rape with murder. We got trial concluded in less than a month, sometime in 2008 if I am not wrong, and the conviction was upheld up to Supreme Court. Need to expedite is one of the facets which the judiciary is expected to dawn upon, so that, because time wipes out the memories. If there is delay in trial, naturally witnesses will not be available in course of time, and many other hurdles should erupt. One of the necessity is for judiciary is to ensure that those who are perpetrators of violence, they are brought to book with utmost expedition. There are many important interventions by Supreme Court. The list is very elaborate. I will be discussing only about some of the important interventions. The case of Aureliana Fernandez in POSH Act. Now, Supreme Court has even observed that this POSH Act should also be considered by the politicians in their political parties. It was thought of as a tool in the workplace alone, but its sweep is being extended so that there is no discrimination, there is no harassment, mental, physical or otherwise at the workplace. So it was, and it is to be noted that in between Vishakha judgment, where Supreme Court, in the absence of any law, Supreme Court devised a methodology to contain discrimination and violence at workplace. After 15 years of that Vishakha case, this act was enacted. In the meantime, that Vishakha case worked. Now, POSH has been directed to be implemented against working women. Supreme Court has given several directions, namely time-bound exercise to be undertaken by the governments to verify whether all ministries, departments, PSUs, institutions, bodies have constituted committees required under POSH Act, and that composition is in terms of POSH Act, ensuring that information as to the constitution and composition, contact details, procedure, etc. are available on the website. Professional bodies at the apex and state level, doctors, lawyers, bankers, etc., universities, colleges, government and private hospitals also required to undertake the same exercise. Another case is we have a very common kind of offense, namely acid attack. This is a very common, especially where the perpetrator conceives of an idea that he has an authority to dominate the girl, and if she says no, then one of the easiest ways to throw acid which will distort her life for remainder of the period. Not only disfigure but also create lot of complications. So in Lakshmi versus Union of India, Supreme Court intervened and issued various directions. In state also, in our state also, this malady ways have been devised to meet this malady. Of course, the scar will not go, but some mitigating steps can be taken. Another case on the same subject is Muthu Lakshmi versus District Collector, where Supreme Court asked, irrespective of the consequences, the victim of an acid attack is entitled to adequate monetary compensation. One of the problems in reporting cases was the fear of society being thinking otherwise, and therefore in Nipun Saxena case, it was emphasized that identity of a woman or a victim, girl victim, should not be disclosed. My published in the print, electronic, social media, name of victim, or even in a remote manner, court to depose as a witness. However, these are instances where laws or judiciary or investigating agencies have a role. But unless the society rises to the occasion, we cannot conceive of these agencies alone tackling the problem. Take for example, with girl child is most abused in the family itself, either by relations or by friends. Now, how to tackle unless there is the society awareness and society takes responsibility of such an abuse? I'm sure that the panelists and our participants would be deliberating on the subject, and as Mr. Nishit had introduced that they have done a lot of work in Bihar and in Andhra Pradesh, and the study and the report data, I'm sure will be utilized by those who are administering law, who are connected with administration of laws, and including police and judiciary both as well. Thank you very much.